Hello everybody. Today we are going to discuss what is evidence and different kinds of evidence. हमने हमारी पिछली वीडियो में लास्ट वीडियो में we discussed about section 1, section 2, section 3 which talks about interpretation clause. तो interpretation clause के अंदर definitions हैं basically जो जहां पर हमने fact in issue and relevant facts को discuss किया in our last video. So today we are going to discuss what is evidence and what are different kinds of evidence. तो हम सबसे पहले बात करेंगे हाउ इज एविडेंस डिफाइंड अंडर इंडियन एविडेंस एक्ट. Evidence means and includes oral evidence and documentary evidence. Now, oral evidence means the statement which the court permits to be made by the witnesses before it. So, whatever the statements court permits or requires to be made before it by the witnesses, it comes under the oral evidences. And such evidences are made in regards to the fact or inquiry conducted within the court. Now, this is oral evidence, and it also includes documentary evidence, which means which usually covers all the documents and also electronic records which are produced for inspection before the court. Now, this is the definition given of evidence under section 3 in interpretation clause under Indian Evidence Act. When we talk about different kinds of evidence, like what are the different kinds of evidences discussed in Indian Evidence Act and which are used in court are usually there are n number of evidences classified on the basis of on various bases and on the basis of various classifications. But the major varieties of evidences are being discussed today here in this video, and those are, the very first is best evidence. So best evidence is basically the original evidence or primary evidence, right? So primary evidence is considered to be the best evidence because that completely decides the fact in issue, and fact in issue is what, as we have discussed in the last video, as defined under section 3. Now this is the best evidence. Coming on to another type of evidence, that is circumstantial evidence. Circumstantial evidence को समझने के लिए what we have to understand is कि it is based on circumstances. तो होता क्या है कि when evidence is given of any evidence is given of fact in issue, then it is considered as direct evidence. Whereas if any evidence is given of any relevant facts or on the basis of some circumstances, then it becomes a circumstantial evidence. So because evidence is given on the basis of circumstances, so circumstances के अंदर से we have to infer, we have to use the deductive reasoning so as to use that evidence in fact in issues. And to support the fact in issue, we have to use that evidence after inferring the information or after conducting the deductive reasoning. So that becomes a circumstantial evidence because that is an evidence given of any relevant fact or on the basis of any circumstances. Now, suppose for examples, like we can understand this from an example, that is if A is charged with murder of B. Now the evidence that now if C is a witness, suppose in this case, now C if states that C saw A stabbing knife to B, like A is that C saw that A has committed a murder of B, then in that case it is a direct evidence because it is a direct evidence and because C has seen the same. But if C states that he has seen A running with a blood-stained knife, then it is based on circumstances. So that leads to a circumstantial evidence. So this is an example to understand how the direct evidence and circumstantial evidence are differentiated. Now coming on to the point that circumstantial evidence, whenever we talk about circumstantial evidence, it is been there are certain principles which are to be followed before deciding the case on the basis of circumstantial evidences. And the very important case in this is Sharad Birdi Chand versus State of Maharashtra. इस केस के अंदर 5 principles were given, which are also considered as a panchsheel of proof of case based on circumstantial evidence. So these are the golden 5 principles. These principles, or we can say it as a test, which are necessary to be satisfied so as to prove a case on the basis of circumstantial evidence. The very first is that circumstantial evidences which are circumstantial evidences which are considered must the guilt must be inferred from such circumstantial evidence, and such guilt must be established in a firmly manner. Alright, the first is that there has to be firmly establishment of guilt from the circumstances. The second is that facts so established should be considered, so should be consistent with the hypothesis of guilt only. It should not be inconsistent with any other hypothesis. It should be consistent with the hypothesis of guilt of the accused. The third is that it should have a definite tendency. It should contain the definite tendency towards pointing a guilt of the accused. So it must point towards the circumstances must lead towards the guilt of the accused. Now the fourth is that it should exclude every possible hypothesis except the one which is to be proved. कोई भी और escape provision नहीं होना चाहिए, उसकी और कोई hypothesis नहीं lead होना चाहिए from that circumstances except the thing which is required to be proved. And the last is that when these circumstances are cumulated, then it must form a chain of custody. Sorry, it must form a complete chain, and there shall not be any escape. It should form a complete chain leading towards the guilt of the accused. So if the circumstances are cumulated, then a complete chain must be formed. If these tests are fulfilled, as stated from the case of Sarad Birdi Chand versus State of Maharashtra, then a case can be decided on the basis of circumstantial evidences. So circumstantial evidences are though basically in priority less than a direct evidence, but a case can be considered on the basis of circumstantial evidence if these 5 golden principles are satisfied, as stated in the case of Sharad Birdi Chand versus State of Maharashtra. अब हम आते हैं another kind of evidence, that is corroborative evidence and substantive evidence. Talking about corroborative evidence and substantive evidence itself says that any evidence which decides the fact and issue. So if any evidence which decides the fact and issue or relevant fact is considered as a substantive evidence. But there are several evidences which are not, there are several statements, maybe made oral or written statements, which are not considered as a substantive evidence. But those statements can be considered to corroborate the substantive evidence. ओके तो यहाँ पर अपन इसको ऐसे समझेंगे कि substantive evidence is the one which is used basically given for the fact and issue or relevant facts, but the corroborative evidence is not having that much value, and thereby it is used to corroborate the substantive evidence. It is used to corroborate substantive evidence as permitted under section 156 and section 157 of Indian Evidence Act, जो हम आगे डिस्कस करेंगे. On the basis of testimony is used to corroborate. And so basically in these cases the corroborative evidence is used to corroborate the substantive evidence. So corroborative evidence deals with the corroboration. It deals with adding the value to the substantive evidence so as to prove the fact and issue with required with the required aspect, that is where the fact and issue is clearly and explicitly resolved through such evidences. So corroborative evidence requires the corroboration and is used by way of corroboration with substantive evidence. It is basically used along with the substantive evidence, whereas substantive evidence is sufficient in itself. Now coming on to another kind of evidence, that is direct and indirect evidence. Direct evidence is basically those evidences which are actually perceived by the human senses, which are actually perceived by the persons through their own human senses. So that is considered as direct evidence. Such as example, any eyewitness to a murder is a direct evidence because he has seen the same, right? He saw that A committed a murder of B. So that is a direct evidence because he has perceived through his own senses. And it proves the very fact and issue. And if there is a direct evidence, then there is no need to conduct a deductive reasoning or there is no need to draw an inference from any circumstances because it's a direct evidence. It directly proves the fact and issue and thereby it decides the case. So this is what about direct evidence. When we talk about indirect evidence में क्या होता है कि they are generally not admissible. इसको मैं एक example से समझते हैं between direct evidence and indirect evidence. Suppose A is charged with murder of B by stabbing him. Okay, so now in this there are 4 witnesses, C, D, E and F from the prosecution side. Now C says that he saw A stabbing B. Alright, C बोलता है कि मैंने देखा A को चाकू घुसाते हुए B के अंदर. Alright, B की बॉडी में. और D बोलता है कि D says that he heard the cry outs of B that A is stabbing him. वो उसका चीखना, उसका चिल्लाना सुनता है that A is stabbing B. ठीक है, ये बोलता है D. अब E बोलता है कि he saw A running with the blood stained knife in his hand. ठीक है, तो C बोलता है कि उसने देखा कि D बोलता है कि उसने सुना और E बोलता है कि he saw the blood stained knife in the hand of A running from the crime scene. Now this C, D, E are considered as a direct evidence, whereas there was another witness, that is F. He says that he heard from C that C saw A stabbing B. C वो बोलता है कि उसने C से सुना ऐसा कि A ने B के अंदर चाकू घुसाया था. तो this is something which is hearsay evidence. So this is considered as indirect evidence. तो यहाँ पर C, D और E के सारे एविडेंसेस के सारे स्टेटमेंट्स कंसीडर करेंगे एज अ डायरेक्ट एविडेंस, वेयरएज जो एफ है वो क्योंकि ये बोल रहा है कि मैंने सी से ऐसा सुना, so that's why it is a hearsay evidence and it is considered as indirect evidence because he has not perceived the same thing with from his own senses, and that's why it becomes an indirect evidence. So इसलिए it is necessary for a direct evidence, for evidence to be considered as direct, that he must perceive through his own senses. अगर वो नहीं कर पा रहा है through his own senses, he has not seen, heard, then in that case it becomes indirect evidence. अब हम आते हैं hearsay evidence पे. Hearsay evidence again, these are evidences which are not admissible usually, and the reason why these hearsay evidence are not admissible are because that it does not fulfill any the person giving these evidences does not feel any responsibility. There are ample scope of committing fraud. Additionally, the truth is diluted in this case because you can't trace the original person who has made the statement, so truth is diluted. So that's why hearsay evidences are basically not admissible. Also, when we talk about there are certain exceptions to hearsay evidence wherein even though evidence is hearsay, it would be admissible in the case of dying declaration, in the case of confession, or in the case of res geste. So in these cases, why are these an exception to hearsay evidence? Because of two reasons. First is either they are relevant to the fact in issue, or because of the relevancy, or there is a necessity because the person is not available. The person from whom the evidence is to be sought is not available, so we are relying on the hearsay evidence. Either that may be the reason, or because of higher relevancy, higher magnitude of relevancy, we are taking those hearsay evidences into consideration. These two are the reasons why these exceptions to hearsay evidences are there, so that even though general rule is hearsay evidences are not admissible, but in dying declaration, confession, or res geste, these hearsay evidences are also admissible because of these two reasons, that is relevancy and the person is not available. Alright, now coming on to another kind of evidence, that is oral evidence and documentary evidence. Oral evidence is basically the Indian Evidence Act requires that a person who has perceived something from his own senses is only required to make the statement and no one else can make the oral statement. So that is considered as oral evidence. Whereas documentary evidence means the original copy of documents to be produced before the court for inspection. Because original copy is produced, why? Because to avoid the tampering or any sort of fraudulent act on such documents, the act mandates that original copy of the document is to be produced before the court for inspection. So that original copy is considered as a documentary evidence, and in oral evidence, the person who has perceived something through his own senses can make the statement before the court, and not any other person who has not perceived something from his own senses. अगर आई विटनेस ऑफ मर्डर है, then he can make an oral evidence before the court, but the person who has not actually seen it but heard from someone cannot make the oral evidence before the court. Alright, so this is all about oral evidence and documentary evidence. अब एक last type of evidence बचता है primary and secondary evidence. प्राइमरी एविडेंस डिस्कस्ड हुआ है सेक्शन 62 ऑफ इंडियन एविडेंस एक्ट के अंदर, और सेकेंडरी एविडेंस डिस्कस्ड हुआ है सेक्शन 63 ऑफ इंडियन एविडेंस एक्ट के अंदर. नाउ प्राइमरी एविडेंस, द वर्ड इटसेल्फ सेज दैट दिस इज द मेन प्राइमरी एविडेंस, दिस इज द प्रिंसिपल फैक्ट, दिस इज द प्रिंसिपल डॉक्यूमेंट व्हिच वुड बी deciding the entire fact in issue, right? So it means the document produced before for the inspection of court. Alright, so अब यहाँ पर section 62 ये बताता है कि where there is any document which is signed or executed in several parts, then each part is a primary document, each part is a primary evidence of the document. Alright, additionally, where if document is मतलब यहाँ पर इसको अगर अपन समझे तो ऐसे समझ सकते हैं कि अगर कोई डॉक्यूमेंट है, उसके हर पेज पे किसी ने साइन किया है, तो देन उसके डिफरेंट पेजेस पे अलग पेजेस पे साइन हुआ है, तो एवरी पेज इज अ प्राइमरी एविडेंस फॉर दैट एंटायर डॉक्यूमेंट, राइट? नाउ कमिंग ऑन टू अनदर पॉइंट वेयर डॉक्यूमेंट इज एग्जीक्यूटेड इन काउंटर पार्ट. बेसिकली काउंटर पार्ट मतलब कि द कॉपी ऑफ ओरिजिनल डॉक्यूमेंट. इफ डॉक्यूमेंट इज executed in a counterpart, then each counterpart is a primary evidence against the party executing it. पार्टी एग्जीक्यूटिंग इट, जो भी पार्टी एग्जीक्यूट कर रही है उस काउंटर पार्ट को, वो उसके अगेंस्ट प्राइमरी एविडेंस बन जाता है, एंड नॉट अगेंस्ट द पर्सन हु हैज नॉट एग्जीक्यूटेड इट. सो दिस हैज टू बी टेकन इनटू कंसीडरेशन कि पर्सन जो हु इज एग्जीक्यूटिंग द डॉक्यूमेंट, who is executing the counterpart, only against that person the document becomes a primary evidence, and not against those who are not executing it. All right, by saying by word executing means the person who is signing to that copy of original document, to that counterpart. Now the last point is under section 62 of primary evidence is that where number of documents are made by one uniform process, such as by way of lithography or photography or printing, then each such document is a primary evidence of content of the rest. इसको हम पॉइंट को एग्जांपल से समझते हैं. सपोज प्रिंटिंग ऑफ अ फोटो, जो फोटोज हम खिंचवाते हैं, प्रिंटिंग ऑफ अ फोटो एट वन टाइम फ्रॉम ओरिजिनल क्लिक इज अ प्राइमरी एविडेंस. जो ओरिजिनल क्लिक हुआ उसके बाद हमने 10 कॉपी 20 कॉपी जो भी हमने डिमांड करी फोटोग्राफर से, वो एक यूनिफॉर्म प्रोसेस के थ्रू जितनी भी फोटोज आई हमारे पास, वो है प्राइमरी एविडेंस, वेयर एज द कॉपीज ऑफ दोज फोटोज इज कंसिडर्ड द सेकेंडरी एविडेंस. अब आपको क्लियर हो गया होगा कि बाय वे ऑफ ओरिजिनल मेथड, बाय वे ऑफ ओरिजिनल क्लिक, व्हाटएवर फोटोज आर ड्रॉन फ्रॉम द मशीन आर प्राइमरी एविडेंस, बट द कॉपीज ऑफ दोज फोटोज आर कंसिडर्ड द सेकेंडरी एविडेंस. ठीक है, इसके बाद हम बात करेंगे सेकेंडरी एविडेंस की. तो सेकेंडरी एविडेंस, जैसे मैंने आपको एग्जांपल समझाया कि इट इज अ कॉपी, सो बेसिकली सेक्शन 63 ये बताता है कि इट इज दीज आर द कॉपीज ऑफ ओरिजिनल डॉक्यूमेंट्स व्हिच आर मेड बाय वे ऑफ एनी मैकेनिकल प्रोसेस. ऑलराइट, और इट आल्सो इंक्लूड्स द काउंटर पार्ट्स ऑफ डॉक्यूमेंट्स एज अगेंस्ट द पार्टीज हु डिड नॉट एग्जीक्यूट देम. अब यहाँ पर ये पॉइंट डिफरेंशिएट करता है सेक्शन 62 और 63 को कि ऑल द काउंटर पार्ट्स are the primary evidence for the person who executed them, but these counterparts are the secondary evidence for those who did not execute them. All right, counterparts मतलब copy of original document, जिसने साइन करी उसके लिए उसके अगेंस्ट वो प्राइमरी एविडेंस बन गया, जिसने नहीं करी उसके अगेंस्ट वो सेकेंडरी एविडेंस हो जाता है. So this is the point to be understood, so which creates a demarcation between section 62 and section 63 with regards to counterparts, with regards to execution of counterparts. एक और पॉइंट है सेकेंडरी एविडेंसेस का, जिसमें कॉपीज मेड फ्रॉम और कंपेयर्ड विद द ओरिजिनल डॉक्यूमेंट. सपोज कोई पर्सन ओरिजिनल कॉपी देखकर कुछ ड्रॉ करता है सेम टू सेम एज इट इज, या फिर कुछ लिखता है या कुछ भी ड्रॉ करता है, या राइट मतलब इधर ही राइट्स और ही ड्रॉज ऑन द बेसिस बाय लुकिंग एट द ओरिजिनल कॉपी so as to make it similar to that original copy is also a secondary evidence. Even though he has not done it by mechanical process, he has done by his own human effort, still it will be considered as a secondary evidence because it's a copy of original. So these three things are considered as secondary evidence. The first is counterpart, second is copy of any original document by way of mechanical process, third is copy from or compared with any original document by way of some human efforts. Okay, so these are considered as secondary evidences. So primary evidence and secondary evidence पे जब हम compare करते हैं तो basically primary evidence की admissibility ज़्यादा होती है. Reason being कि these are there is originality and aspect covered in primary evidence. So these were the different kinds of evidences which are used in court of law. And if in case आपको इसमें कोई भी doubt आता है, you can mention the same in the comment box. And अगर आपको वीडियो अच्छी लगती है then please like, share and subscribe. Thank you.